The loan officer's voice cracked when she read the signature date out loud, because that was the exact week I was lying in a hospital bed in Charlotte recovering from gallbladder surgery, unable to hold a pen, let alone sign my name to a $280,000 second mortgage on the home my husband and I had spent 12 years paying down. Detective Ramirez slid the folder across the table toward Diane Whitfield, my mother-in-law, and asked her to explain how my signature appeared on a document notarized in a county I had never once set foot in. She opened her mouth to answer, and nothing came out, because she didn't know that 3 months earlier, I had already hired a certified forensic document examiner who matched every loop and slant of that forged signature back to her own handwriting samples, pulled straight from the birthday cards she'd been sending me for a decade. She thought she had gotten away with it clean. She had no idea I'd been building a case against her since the day the first strange letter from the bank showed up in my mailbox. My name is Rachel Bennett, I'm 44 years old, and I live in a quiet neighborhood just outside Asheville, North Carolina, in the same house my husband Mark and I bought back when our daughter Emily was still in diapers. If you're the kind of woman who has ever sat across a table from a mother-in-law who smiled at you while quietly working against you, I want you to stay with me through this whole story, because the ending is going to feel like justice finally showing up on time. And if this story pulls at something in you, do me a favor and subscribe to Silent Revenge Stories, because we tell these stories every single week, real accounts of women who stayed calm, stayed smart, and won. Drop a comment below and tell me if you've ever had a mother-in-law who thought family loyalty meant she could take whatever she wanted from you, because I read every single one, and trust me, by the end of this you're going to have plenty to say. It started so small that I almost missed it. Diane had always been what people politely call a difficult. She'd raised Mark alone after his father left, and she never let either of us forget the sacrifices she claimed to have made, even though most of what I'd heard over the years came from Mark's older brother, Todd, describing a very different childhood, one where Diane spent grocery money on herself and left the boys to figure out dinner. Diane had a gift for turning herself into the victim in every room she walked into, and for the first 6 years of my marriage, I mistook her constant interference for love. She had a key to our house. She rearranged our kitchen cabinets when she helped during Emily's birth. She once returned a crib I had picked out and replaced it with one she liked better, using my credit card without asking, and when I confronted her, she cried so hard that I ended up apologizing to her instead of the other way around. I didn't know yet that this pattern, small boundary violations dressed up as love, was rehearsal for something much bigger. The first real red flag came on a Tuesday afternoon in March, when I opened a piece of mail addressed to both Mark and me from a lending company I had never heard of, welcoming us to our new home equity line of credit. I remember standing in the kitchen reading it twice because none of it made sense. We hadn't applied for any home equity loan. Mark was traveling for work that week, so I called the number on the letter myself, and a customer service representative confirmed there was indeed an active second mortgage on our property, originated 2 months earlier, for $280,000, with the funds already disbursed to an account ending in the digits 4471. When I asked whose account that was, she told me she couldn't disclose that information without a formal dispute filed, but she could confirm both borrower names on file were Mark Bennett and Rachel Bennett. My hands went cold. I had never signed anything. I had never even talked to a loan officer. I called Mark immediately, and his first instinct, the one that would define the next several weeks, was disbelief bordering on defensiveness, not of me, but of the situation itself. He kept saying there had to be some kind of clerical error, some kind of identity theft scam that had nothing to do with our family. I wanted to believe that too. It would have been so much easier. But something in the back of my mind kept circling around one detail from the letter, an address listed for a secondary contact on the loan file, an address I recognized instantly because I had mailed Christmas cards there for a decade. It was Diane's house. I didn't say anything to Mark about that detail yet. I needed to be sure before I threw a grenade into our marriage over a hunch. So I did what any woman with a paralegal background and 11 years of experience preparing exhibits for civil litigation attorneys would do. I requested a certified copy of the loan documents directly from the title company, citing my rights as a named borrower on the account. It took 9 business days, but when the envelope finally arrived, I sat alone at my kitchen table and opened it with shaking hands. There it was. My signature, notarized, dated the 14th of January, the exact week I had been recovering from emergency gallbladder surgery at Mission Hospital, unable to leave my bed, let alone drive 40 minutes to a title office in Hendersonville to sign loan paperwork. I still had the hospital discharge summary in a folder in my nightstand. The dates didn't just raise suspicion. They created an alibi I didn't even know I would need. That night, after Emily went to bed, I told Mark everything, laying the discharge papers next to the notarized signature page so he could see it with his own eyes. I watched something shift in his face, the same face that had defended his mother for 6 years, crumble into a kind of quiet horror. He recognized her handwriting too. He'd grown up watching her sign his school permission slips with that same distinctive capital B, the one that looped backward instead of forward, a quirk no forger usually thinks to fake because they're so focused on copying the letters they forget the smaller habits underneath them. We sat at that table until nearly 2 in the morning, and by the end of it, Mark wasn't defending her anymore. He was asking me what we needed to do to prove it. The next morning, I called an attorney who specialized in real estate fraud, a sharp, no-nonsense woman named Patricia Alvarez who had built her entire practice around cases exactly like mine. She told me something that changed the entire trajectory of the next 4 months. She said the single most important thing I could do right now was nothing dramatic. No confrontation. No accusations at Thanksgiving dinner. No tearful phone call to Diane demanding answers. Because the moment Diane realized we were onto her, she would have every opportunity to destroy evidence, coordinate her story, or worse, drain whatever remained of that $280,000 before we could trace where it went. Patricia's advice was simple and terrifying in its patience. Gather everything first. Confront her last. So that's exactly what I did. I contacted a certified forensic document examiner named Howard Kessler, a man who had spent over 20 years testifying in courtrooms across the Southeast about handwriting authentication, and I sent him 12 years of Diane's handwritten birthday cards, holiday notes, and even a grocery list she'd once left at our house, alongside the disputed signature from the loan documents. 2 weeks later, his written report landed in my inbox, 17 pages of detailed analysis concluding with a 94% confidence match between Diane Whitfield's natural handwriting and the forged signature on our second mortgage. He specifically pointed to that backward-looping capital B, the pressure patterns in her pen strokes, and the spacing between her first and last name, all consistent with her authentic writing samples and inconsistent with a genuine attempt by me to sign my own name. While Howard worked on the handwriting analysis, I quietly pulled our credit reports and traced the disbursed funds using the account number the bank representative had let slip. Working with a private forensic accountant Patricia recommended, a methodical man named Gerald Osei, I discovered that account ending in 4471 belonged to a small business Diane had opened 18 months earlier called Whitfield Family Catering, a business that, as far as I could tell from public records and a very telling Facebook page with only 41 followers, had never catered a single actual event. Gerald traced the money in stages. $90,000 had gone toward paying off a defaulted business loan Diane had taken out years earlier under a different LLC that had already failed. Another $60,000 had gone directly into Todd's checking account, Mark's older brother, the golden child who had somehow always needed bailing out of one financial disaster after another. The remaining balance had been spent on a leased Cadillac Escalade, a kitchen renovation at Diane's own house, and, almost unbelievably, a down payment on a vacation condo in Myrtle Beach that Diane had been not so subtly hinting she wanted to buy for over a year. Around this point in the investigation, just when I thought I understood the full scope of what she'd done, we hit our first real complication. The notary whose stamp appeared on the forged documents, a woman named Bonnie Faircloth who worked out of a shipping and printing store near Diane's neighborhood, initially refused to cooperate when Patricia's investigator reached out, claiming she had no memory of the transaction and threatening to lawyer up if we kept contacting her. For nearly 2 weeks, that notary's silence became the single biggest obstacle in our case, because without her confirming she never actually witnessed me signing, Diane's defense could later argue the notarization was simply a paperwork oversight rather than evidence of deliberate fraud. Patricia and I spent long nights strategizing, and I remember genuinely wondering if this entire mountain of evidence would collapse because one nervous notary was afraid of losing her business license. The break came from an unexpected direction. I remembered that Diane, in one of her many oversharing phone calls to me the previous spring, had mentioned in passing that she and Bonnie went to the same nail salon and that Bonnie had done her a huge favor with some paperwork because they were, in Diane's words, practically sisters. That single sentence, tossed off casually months before I even suspected anything, became the thread Patricia's investigator pulled on. Faced with the choice between losing her notary commission for knowingly witnessing a signature that never happened, or cooperating with a fraud investigation as a witness rather than a target, Bonnie finally agreed to a recorded statement. She admitted, on tape, that Diane had brought the documents to her already signed, told her I was running late and had asked her to notarize it anyway as a favor between friends, and that Bonnie, against every rule of her profession, had done it without ever laying eyes on me. With Bonnie's statement in hand, along with Howard's handwriting report and Gerald's financial trail, Patricia said we finally had what she called a complete evidentiary package, strong enough not just for a civil fraud lawsuit to void the mortgage, but strong enough to hand directly to law enforcement for criminal charges. This is usually the part of the story where people expect me to have exploded into some dramatic confrontation, screaming at Diane across a dinner table, but that's not what happened, because by then I understood something Patricia had told me on our very first call. The quietest revenge is the one they never see coming until it's already legally finished. Before we went any further, though, there was one more piece I needed, something that would matter enormously later, not for the fraud case itself, but for making sure Diane could never again claim victimhood to the rest of the family, the way she always had for 30 years. I wanted her own words, in her own voice, admitting what she'd done. So on a Sunday afternoon in early June, I invited Diane over for what she thought was an ordinary visit to see Emily, and Mark, coached carefully by Patricia on exactly what to say and what never to say, wore a small recording device clipped inside his shirt pocket, perfectly legal under North Carolina's one-party consent law, since he himself was a party to the conversation. He gently pushed the conversation toward the catering business, toward Todd's recent, generous gift from her, toward the new kitchen countertops. Diane, comfortable and unguarded in her son's living room, bragged. She actually bragged, laughing about how your father's estate money was never going to be enough, and how she'd found a clever way to get us all what we deserved without anyone having to know, specifically naming the loan, specifically naming my signature, saying, almost proudly, that she'd always been good at matching my handwriting since I used to sign your school notes for you back when we lived together that one summer, a detail that was completely fabricated since I had never lived with Diane a single day in my life, but a detail that, on tape, sealed her own confession with a lie so casual it proved just how comfortable she'd become getting away with things. That recording, combined with the forensic handwriting report, the financial trail from Gerald, and Bonnie's sworn statement, went straight to Patricia's office the following morning, and within a week, it went to the district attorney's office in Buncombe County. Here is where I want to pause and tell you honestly that the middle of this fight was the hardest part, harder than the discovery, harder than the confrontation. Because filing charges against your own child's grandmother, against a woman who still showed up at Emily's soccer games with a cooler full of orange slices, meant watching my daughter ask why Grandma Diane suddenly stopped coming around, meant sitting through holidays where half of Mark's extended family sided with Diane simply because she was better at performing hurt feelings than I was at performing patience. Todd stopped speaking to us entirely once he realized the $60,000 sitting in his account was now part of a criminal investigation. For nearly 3 months, it felt like we were losing an entire side of our family just to prove something that felt, in my gut, undeniably true. But the evidence didn't care about holiday dinners or hurt feelings. It sat there, patient and complete, exactly the way Patricia had promised it would if I just gave it time. And here's what I want you to understand about where this story is heading, because we are getting close to the moment everything finally came to a head, the moment I stood in a courtroom in downtown Asheville and watched a judge look at Diane Whitfield the way you look at someone who has just run out of excuses. The moment a woman who had spent 30 years controlling every room she walked into finally sat in a chair with absolutely no control left at all. The criminal fraud unit moved faster than any of us expected once they reviewed the full file. Forgery of a financial instrument combined with mortgage fraud carries serious felony weight in North Carolina, especially at that dollar amount, and the recorded confession made the prosecutor's decision almost effortless. Diane was arrested on a Thursday morning in the parking lot of her own hair salon, an image that, I'll admit, gave me a complicated flicker of satisfaction I hadn't expected to feel. She was charged with felony forgery, uttering a forged instrument, and obtaining property by false pretenses. Bail was set. She posted it within hours using money that, ironically, came from Todd, the same brother whose gift had started this entire chain of theft. The civil side moved in parallel. Patricia filed to void the fraudulent mortgage entirely, arguing successfully that since the signature was forged and the notarization fraudulent, the loan was never legally valid in the first place. This is the part one really want other women listening to understand, because so many people assume a forged mortgage means you're stuck fighting the bank for years. It doesn't have to. Once we presented the forensic report and the notary's sworn statement to the lender's fraud department directly, along with a formal police report, the bank's own internal investigators moved to have the lien released within 6 weeks. They wanted nothing to do with a fraudulent loan once real evidence was on the table, because banks are far more afraid of regulatory liability than most people realize. Our home, the one Diane had quietly mortgaged out from under us without either of us knowing, was ours again, free and clear of that debt, before the criminal case had even reached its first hearing. The criminal trial itself took another 5 months to reach resolution, mostly through pretrial motions and a plea negotiation that Diane's attorney pushed hard for once he heard the recorded confession played in a pretrial hearing. I sat in that courtroom on the day the plea was formally entered, watching Diane in a gray cardigan I recognized from a dozen Christmas dinners, watching her lawyer try to frame 30 years of manipulation as a mother trying to help her family in a misguided way. The judge wasn't interested in that framing. She was looking at a $280,000 felony, a forged legal document, a corrupted notarization, and a confession recorded in Diane's own voice bragging about deceiving her daughter-in-law's identity to fund a fake business and bail out her favorite son. Diane pled guilty to felony forgery and obtaining property by false pretenses, receiving a suspended sentence with 5 years of supervised probation, full restitution order to cover the legal fees, forensic costs, and financial damages we had incurred, and a permanent felony record that would follow her for the rest of her life. She also lost her notary friend Bonnie's cooperation forever, and lost something I don't think she ever expected to lose, which was her ability to ever again present herself to this family as the innocent, self-sacrificing grandmother she had spent decades performing. The restitution order alone came to just over $91,000, covering Howard's forensic fees, Gerald's accounting work, Patricia's legal costs, and the emotional distress damages folded into the final settlement. I want to be honest about something here, because I think it matters. I didn't do this to bankrupt her or to humiliate her. I did it because I refused to let a woman who had spent 30 years testing boundaries finally succeed at stealing my home, my credit, and my family's future, all while smiling at Sunday dinner and pretending she loved us. Evidence doesn't lie. Evidence doesn't manipulate a room. Evidence just sits there, calm and complete, until the exact right moment when it becomes undeniable. Today, Diane lives alone in a smaller apartment across town, her catering business dissolved, her relationship with Todd strained after the restitution order forced him to return the $60,000 that had funded his own rescue. Mark speaks to her maybe twice a year, brief, guarded calls that never quite return to what they used to be, and honestly, I think that's exactly the amount of relationship she earned back. Emily still asks about her sometimes, and we've told her, in language appropriate for an 11-year-old, that Grandma Diane made some very serious mistakes and broke some very serious rules, and that sometimes even people we love have to face real consequences for the choices they make. I think that's a more honest lesson than pretending forgiveness has to mean forgetting. If there's one thing I hope you take from this, it's simple. If your gut tells you something is wrong, even something as small as a strange letter in your mailbox, trust that instinct enough to quietly start asking questions before you accuse anyone of anything. Patience and documentation will always beat a shouting match at Thanksgiving dinner. Evidence doesn't need you to be loud. It just needs you to be thorough, and it needs you to wait for the moment it can speak for itself, in a courtroom, in a forensic report, in a recording that captures someone's own voice confessing to exactly what you always suspected. That patience is what turned a devastating betrayal into a clean, permanent legal victory, one that got my home back, protected my daughter's future, and finally held Diane Whitfield accountable for the first time in her life. If this story meant something to you, subscribe to Silent Revenge Stories so you never miss the next one, because we release a brand new true account every single week, and I promise you, some of them go even further than this one did. And before you leave, drop a comment below and tell me the one lesson you're taking away from my story, whether it's about trusting your gut, documenting everything quietly before you confront anyone, or simply learning that family loyalty should never mean silence in the face of theft. I read every comment, and I would genuinely love to hear which part of this story hit closest to home for you. Thank you for staying with me through all of it, and I'll see you in the next story.